Old Navy sends out an email, and the email has false scarcity and
subject line says limited time only, buy one, get one, act now. They want consumers to open the email. Email is incredibly highly converting, easy to get people's attraction. The question that went up to the Washington Supreme Court was, what is a false or misleading subject line under Washington law? And the Supreme Court came out and said, no, it's a false claim.
And so here's my understanding of the penalty. $500
Correct.
per email.
Per email.
Per recipient.
Per recipient.
So if I send to my 10,000 person list, today only, might sound irresistible, but if you send that subject line to a Washington state recipient, when the deal's still running next week, you could owe up to $500 per email sent or even more. That's because on April 17th, Washington State Supreme Court broadly interpreted CEMA to forbid any factual misstatement in commercial email headers, even if the body clarifies things later. I'm Emma Rainville, and I'm here with my co-host, Ryan Poteet of Gordon Reese. And in this episode of Marketing on Trial, we'll unpack the Brown versus Old Navy decision. What counts as factual versus puffery, how to audit subject lines, and how to avoid turning your next email campaign into a costly legal misstep. What's going on here, Ryan? I want to attempt to keep this concise, but it's not just Washington State, but we're specifically talking about Washington State because of the stuff that came out in April and because of Brown versus Old Navy. So let's start with Brown versus Old Navy.
So large retailer sends commercial emails like so many do. Subject line says limited time only, buy one, get one, act now. Whole reason they want consumers to open the email. Email is incredibly highly converting, easy to get people's attraction. Company removes to federal court, says, hey, by the way, sorry, you can't state a claim. There's nothing false or misleading in this subject line. Or if there is, it's not concerning the commercial nature of this email, which is what most people thought the statute meant. You can't misrepresent that this is like a public interest piece when it's actually like an ad, right? Question gets certified to the Washington Supreme Court. Supreme Court says, nope, this applies to any misstatement or any factual misstatement in the subject line of an email, regardless of what's in the body. So I think it was a little bit surprising that the court went this way, but overall it brings Washington statute more in line with California, for instance, 17529, where you can't falsify or misrepresent header information, which includes the to from fields and then subject lines. And
let's talk about the subject lines for a moment, because there's a couple things that I think are a little bit nuanced that I want to ask. And so I took an email course some time ago, and one of the things that they taught us was because of, I want to say it was a pharmacy that sued Google. You can't put in spam anything that says like your order confirmation or appointment confirmation. So technically, if I'm trying to sell you something, that has absolutely nothing to do. Are you following me? You look like a big question mark on your face.
No, so I think where you're going is, can I, as a brand or an email marketer, can I send you an email with a subject line, your upcoming appointment? It has absolutely nothing to do with your upcoming appointment.
Right.
No, that would be mischaracterizing the body of the email.
So the whole
trying to
strategy I spent $12,000 learning is
pretty much.
Okay, perfect.
Yeah. I mean, so, and I'll say this.
This is why you have to be careful of whose homework you cheat off of.
Well, and this is one of those more kind of fact-dependent
right.
issues that kind of comes out in litigation. Are you going to get sued alone for the subject lines? Depending on what they are, probably not. There's usually going to be another issue that we'll talk about later called traceability of who actually sends the email. But
let's talk about Brown versus Old Navy.
So the subject line, I mean, it needs to accurately describe the contents of the email. And unfortunately, in that case, the promotion that was being run was not truthful. Or I don't know if it was truthful or not, but at least that was what the allegations in the complaint were. And that it wasn't a limited offer. And it was just trying to trick people into opening
false
these emails.
Scarcity.
Yeah. And so you're not supposed to be doing that in any sort of copy, but especially where there's a statute saying that you can't have a false or misleading subject line. A false claim in a subject line is going to be interpreted as a violation.
So Old Navy sends out an email, and the email has false scarcity in the subject line. And they get sued by somebody named Brown.
Somebody named Brown.
And
The case is ongoing.
right.
So, I mean, the question that went up to the Washington Supreme Court was, what is a false or misleading subject line under Washington law? Is it what most practitioners thought it meant? Are you misrepresenting the commercial nature of the material that's in the body of the email, or is it actual, a false claim? And the Supreme Court came out and said, no, it's a false claim.
And so here's my understanding of the penalty of this mishap is $500
Correct.
per email,
Per email.
per recipient.
Per recipient.
So if I send to my 10,000 person list,
This
I
ad-
sent 10,000 emails and it's 500 times 10,000 or only the people that opened?
Oh, no, it's however many that you send to them.
Okay.
And there's a bunch of ways that you kind of argue around this of whether or not, someone opted in to receive emails. That is one way to, because really the predicate for a lot of this, especially under California, because that's where most of this litigation is, it's whether or not this is unsolicited. So if you have valid one-to-one opt-in for people agreeing to receive emails, that's going to be a great defense to this. Because at that point, I mean, they're agreeing to receive all these emails. Now, does that cure other deficiencies or violations of the email? Not necessarily, but it's a great argument to have. So, but getting back to more of what we were talking about, like you need truthful stuff in the subject line. When you are sending it out to massive lists, the statutory penalties start to add up, and we've been in the middle of a couple of them.
So California, Georgia, Maryland, and South Dakota all have very similar statute to Washington.
Correct.
This is probably going to roll out every state.
Yeah, I'm kind of surprised it hasn't.
Right.
Everybody hates spam. I mean, even just my work email address is just inundated with stuff.
That's
And
what the promotions tab is for, Ryan.
Outlook doesn't have those.
Right, because you're running on 1922, right?
No,
Anyway.
we're just lawyers. So, but no, I mean, make sure you have truthful subject lines. Don't make false claims in your emails. Otherwise, it's going to be a predicate for statutory penalties.
What's up? We interrupt this podcast to remind you to like and subscribe so that you can always be in the know of when Ryan and I drop a new episode of Marketing on Trial. Also, sign up at www.specialopspodcast.com for our Visionary Vault and get all of our freebies. What haven't I asked that I should have?
Big thing, especially under California, I want to talk about traceability since we're talking about email.
Okay.
So recipients of an email need to be able to identify the sender of that email. It's not the brand. If you're using an affiliate to publish a bunch of emails or send a bunch of emails,
It's the sender.
It's the sender.
It's not
It's
the
the
product,
affiliate.
it's
Yeah,
the
it's
sender.
the affiliate. So you need to be able to identify that affiliate by name, address. Typically, it's
There's
a
to be
company.
a physical address.
Physical
correct? Yeah.
address. The best practice would be it's a corporate entity. At the bottom of the email. I guess there's two ways. You could use a publicly registered domain. If you're not using that, then at the bottom of the email, it needs to have the name of the corporate entity that's sending it, the address that is linked to that corporate entity, and you need to be able to go to a Secretary of State's website. So like wherever you go, you incorporate your entity. So if, Shockwave Solutions, I believe it's a Texas corporation.
It is.
So at the bottom of the email, if you have Shockwave Solutions and an address, you should be able to go to the Texas Secretary of State website and search for Shockwave Solutions, and there needs to be an entity by that name
I don't
as
think
well as an
that I
address.
knew that. So I actually recently bought an address
Okay.
because the address that's linked to my business is my address.
Your home address.
Correct.
Yeah.
And so I bought an address. I'm going to show it to you because this is what you get to do when you do a podcast with Ryan. You get free legal advice. It's great. It was brilliant on my part, by the way. I got Perry Belcher to pay me money to teach me everything I know. I got you to pay to fly out here to teach me all kinds of stuff for free. In all seriousness, though, I'm going to show you mine. But if you go on the Secretary of State, it's going to be my home address for Shockwave.
So the principal place of business for your corporate, whatever information you have in the Secretary of State should match. So I would use the new mail drop or the new address that you have for your business.
To go to the Secretary of State.
Correct.
So just update the Secretary of State.
Correct.
Okay, well, I got off on a little bit of a hinge, and now, of course, I can't find any of my own emails to show you. I'll show you later. But
I'll tell you, I've been in arguments with opposing counsel over whether or not, there is a disconnect in the name of the corporate entity or the address at the bottom of the email. and it's, there's, or they're using.
I knew that there needed to be a physical opt-out address. I knew that.
The unsubscribe link. Yeah, I mean,
Not just the unsubscribe link. There's supposed to be, by law, you have to have a physical address, an opt-out address.
When you say opt-out address,
You have to have a physical address where people can opt out of your emails.
and send them.
Correct. Like your
Gotcha.
ESP requires that. And you will get occasionally, it's really funny, you will get people who will occasionally write in, like handwritten letter, telling you not to send them anything anymore, which is hysterical to me.
Now, probably the easier way to do this would be just to use a publicly registered domain. And so if you use a publicly registered domain and you go to the website registrar, and so for shockwavesolutions.com, I don't know if it is or not, but if it's a publicly registered domain, it'll have all the same identifying information: who owns the domain, contact information.
But I have to have a physical address on the email, no?
You don't have to. No.
Huh. I actually thought that you did.
No.
My ESP,
Your ESP
requires
might
me.
require
Yeah,
it.
my ESP requires me.
But that's
too.
a separate.
Interesting. Okay, so go ahead. I don't want to keep you.
No.
Now I'm like surfing looking for my own emails and I can't find my own email like a jackass. But go ahead, Ryan.
Last time I looked at it, I think you're using a publicly registered domain. So no
Shockwave
issue.
is publicly registered, yeah.
Yeah, so it's only when you're using a privately registered domain is when you're going to have some issues. And so, because then you have to look at the body of the email and is the sender actually identified? And you can get into a bunch of, I would say, polite arguments with opposing counsel of like, okay, so if I click on links in that and that links me to a website and that website is publicly registered or it clearly identifies the sender of the email, is that traceable? It is just much easier to not ever have to have that argument and just have the legal name at the bottom of the email, the legal address, and a working unsubscribe link.
Okay. All really good information. Some things I didn't even know. Yay, Ryan. I'm ready to move on to a checklist. Did I forget anything?
No, I think that's it.
Okay, number 1, run an audit of your email and make sure you are flagging previous emails that have these false subject lines. You want to use that to teach your team, particularly your email provider if you have one. This is like a big problem in direct response in e-commerce, right? Because a lot of us have someone, I'll use Michael Goff for an example, just because I've worked with him so much. Michael Goff is an email list manager. And so when you're working with an external team, you're still responsible ultimately for what goes on your email list. So making sure that you're communicating. I'm sure Michael stays up. I certainly don't mean to blow him up. I'm sure he stays up with all the compliance things, but you need to make sure that you're going back, auditing what was wrong and sending them to whoever's managing your list, whether they be internal or external, and setting those guidelines and have a guideline SOP on emails for this purpose. Update your ESP settings. You're going to create a very specific header compliance filter in your ESP. Add compliance memos. Document why each subject line is permissible. You may get something 3-4 months from now that someone doesn't remember. So make sure if there's a reason why your claim is permitted under the law that you make sure that you tie back why it is, because again, you may not remember later. And then train markers, factual or puffery. We do ratings at our business. Obviously, like there has to be some kind of scarcity. There has to be some reason for people to open. We do it opposite of Gordon Race. You guys do. One is
handcuffs.
Yeah, we do. One is not much risk. 10 is a lot of risk. Anything that lives under a 5, I don't need to see. Anything over a 6, I need to approve. And so you want to create markers like that within your own brand so that you can make sure that you're going to be safe, if you will. So if your subject line says today only, but the same sale runs through tomorrow, it's not clever. It's a $500 per email per recipient risk. Washington's ruling is a game changer, not just for compliance, but for trust. Marketers can still craft compelling emails, but honesty is mandatory the moment the subject line hits the inbox. Now's the moment to audit, adjust, and document your header strategy, especially for Washington recipients, California, Maryland, Georgia, and South Dakota.
Dakota.
Download our subject line compliance checklist featuring audit templates and safe phrasing guidelines in our Visionary Vault. If you haven't signed up for the Visionary Vault, head over to www.specialopspodcast.com and sign up for that. Ryan and I have created a ton of material. The Shockwave team has created a ton of material. You got loads of courses. We never try and sell you anything. We're just giving out free information. The real reason I do this is so I can get free legal advice from Ryan, because he's really expensive and I don't want to buy him a Ferrari. But thank you, Ryan, for doing this with me. This is amazing.
Thanks, Emma. Appreciate it.